All right. Good afternoon, good morning, depending upon where you are. My name is Wendy Venverlo. I'm the Executive Director of NAPSA. It is a pleasure to be with you today, as always. I'm really excited about the content that we're going to bring you today. As many of you know, we released updated standards just a couple of months ago. And so very excited to have experts from the Pretrial Standards Committee of NAPSA here today to talk about those updated standards. Just a couple of housekeeping things. This is being recorded. We will offer this session on our YouTube page. I will be putting some links into the chat so that you can access those resources more easily. Couple other things. We do have a couple of sessions coming up. I don't have those publicly released yet, but we will be offering more free webinars in up through our conference, which will take place in September. So you should be seeing, hopefully in the next week or so, some courses in both April and May that I will be pushing out, as well as other resources. We also hope to be opening registration for our conference, which will take place in Atlanta, Georgia, in September of this year. We hope to be opening the registration for that in April, so be on the lookout for that as well. As far as this webinar goes, you can ask questions for our panelists below in the Q&A feature, and we will be monitoring that actively. You also are welcome to chat with each other in the chat. So with that, again, thank you so much for being here today. I'm going to turn things over to my colleague, Spurgeon Kennedy.
Thanks, Wendy. And joining me is Janet Steen and Elizabeth Simoni, both members of the NAPSA Standards Committee, along with me. Hello, everybody. And we are happy to introduce the NAPSA Pretrial Standards Revision 2024. This is something that we as an association are very proud of. The standards, along with our conference and the certification and the accreditations that we do, are things that we consider unique to us and the things that we want to do to help the field advance. The NAPSA Standards Committee was actually created back in 2018, and it was because while NAPSA has been promulgating standards since 1978, we really didn't have a schedule or routine way of doing it. The 2020 standards, for example, were the first time we looked at those documents since 2004. So we developed the Standards Committee so that we would have a way of keeping the standards current with research that's out there, with statute and case law that certainly changes, and the idea of what is best and promising practice in the pretrial field. Our first product was the 2020 edition of the release standards, and in 2024, the NAPSA Board of Directors approved the revisions and named it Pretrial Standards. So what's kept since 2020? Well, we always want to describe the components of an effective legal and evidence-based system. We updated the standards to the developing body of knowledge about best and promising practices in the field, about the changes in legal definitions and the requirements of fair and reasonable bail decision-making. You might imagine between 2004 and 2020, a lot went on in terms of research, in terms of legal definitions, and in terms of case law. And the 2020 standards really try to encapsulate all of that. We also set a higher standard for what we think is realistic for justice systems to accomplish. The standards have always been thought of as aspirational, but we wanted people to realize that aspirational didn't mean unrealistic. There's really nothing in the standards we think that cannot be achieved by most pretrial agencies and pretrial systems. And we think the standards continue to identify those processes that are fair, rational, effective, and possible. We also wanted to strengthen NAPSA's support of independent pretrial services agencies, the use of validated pretrial outcome assessments, and the abolition of financial conditions of bail. And finally, we went sort of back to the future, back to the 1978 standards by advocating a prohibition of financial conditions of bail. So those were the changes made in the 2020 edition of the standards. In 2024, we kept those from 2020 and we added some new things. We updated the literature about the best and promising practices in pretrial. We included the changes again in bail laws between 2020 and 2024, bail law and case law related to bail. We included as best we can value neutral language to describe justice involved people, such as individual in person instead of defendant, and some system processes such as outcome assessments instead of risk assessments. And we developed new standards. Owing to what we learned from the COVID-19 pandemic, we advocated alternatives to in-person court appearances. We advocated behavioral health and social services as part of pretrial supervision. We kind of refined what we mean by adding those services and support to supervision. We created a standard that discussed work and caseload ratios for critical agency functions. And we created a standard, again, that advocated more use of telephone and virtual reporting over in-person reporting. What hasn't changed, though, and what will always be part of the standards that NAPSA puts into place, is the idea of pretrial system-wide improvements. Our focus will always be on pretrial services agencies. We are the agencies association, but we recognize that if you really want to make substantial long-term change, it's got to be system-wide. It has to involve other agencies. It has to involve other court systems. It has to involve your public service and support systems. This systemic way of doing business really is the only way that we're going to improve justice systems. And NAPSA will always advocate that kind of system-wide approach. So what are the new standards? What do they look like? We're going to peer into that, and I will turn things over to my colleague, Janice Dean.
Thanks, Kenny. So one of the things that we really want to talk about are the guiding principles for pretrial decision making. So pretrial programs should really have these goals in mind in almost anything that they do in their program. So your goal of maximizing release, court appearance, and public safety, right? Those have to be looked at together. So you want to release as many people safely as you can and that are going to appear in court. Bail conditions based on individual risk factors. So, again, we're talking about you don't want to have anything that has blanket conditions. So if you're arrested for retail theft, everyone that gets arrested for retail theft shouldn't have the same conditions. So they should be based on your individual risk factors. There should always start with a presumption of non-financial release. Almost every jurisdiction has non-financial release conditions. And so you should always start there, and there should be reasons why those would either be not followed or changed to make it more stringent. Again, prohibition on financial conditions. You should not have to get out of jail or try to get out of jail by paying money. Money doesn't guarantee appearance. It doesn't guarantee safety. It just holds the people in jail that don't have money and releases the people that have money, regardless of safely being able to release them. So detention as an option for public safety. So your jurisdiction should always have some type of detention option when there is a public safety issue, and victim safety should always be recognized. The essential elements of an effective pretrial justice system, right? These come from the NIC publication on essential elements. We have added a new standard because, like Kenny had said, all from COVID, we realize there's lots of alternatives to in-person court appearance, in-person reporting, things like that. So our first one is law enforcement options in lieu of arrest. So law enforcement should have the ability to do summons arrests They should have the ability, in some jurisdictions will have like lead. So instead of making an arrest, they could take it to a lead. There's lots of jurisdictions now that have the ability for law enforcement to respond with social workers, people, mental health professionals, people that can actually help alleviate that need for an arrest. There could be alternatives for them to go. Bail statute with presumption of OR and progression to conditional release and detention. So your bail statute is going to start with release on your own recognizance with no conditions and progress to through conditional release and detention, again, avoiding all financial costs of bail. Financial costs of bail would be money that you need to pay to get out, money that you need to pay for some type of release condition. So the one that comes to mind most, of course, is electronic monitoring. And so jurisdictions that are like, well, we release all these people, but then there's always that high financial cost of electronic monitoring, depending on how your jurisdiction does that, whether that's through a third-party vendor. But when you're thinking of financial conditions of release, most people just think of that initial, I have to pay $1,000 to get out. There's also things, drug testing, electronic monitoring. Do you charge for your supervision? So things like that are also financial conditions of release. Experienced prosecutor screening of case pre-initial appearance. This should happen in every jurisdiction, and most jurisdictions, because a lot of times pretrial programs don't control that, it's a little bit harder to get that. But when you're talking to your system actors, right, this is really important, along with engaged and active defense representation at that initial appearance, especially when your initial appearance, if there is an option for someone to remain in jail, they should be represented at that point. Sequential bail review. So when you do your initial assessment on someone and they don't get out, you should not just forget about them, right? It's not a one and done. There has to be some type of sequential bail review where your program is going and looking at either certain intervals or in conjunction with your jail or your defense attorneys, that there's a mechanism for people to be reviewed if they haven't been released at that initial hearing. Established pretrial services agency. We want to make sure that that agency is independent. You want to make sure that you are not overly engaged with either side. You should be kind of that neutral third party to provide information to the court in making the best decision they can on those releases. Validated pretrial outcome assessment. So you want to make sure that, I know a lot of people use either a established assessment. So a lot of jurisdictions use the public safety assessment from the Arnold Foundation. And again, you can use that, but you want to make sure that at some point you try to get that validated to your own population. Supervision tied to individual risk levels and factors. So you want to make sure you're not having any blanket conditions, and any risk that you're trying to mitigate, right? The factor that what you're doing to try to mitigate that risk actually works. Alternatives to in-person court appearance. Over COVID, I don't know about you and your jurisdictions, but for our preliminary hearings, which we normally run about 87% of a appearance rate, 13%, and it has a lot to do with sometimes, different factors. But during COVID, when people could appear by video for these hearings, we had like a 93% appearance rate. So it does help. We have worked really hard because a lot of the appearances for court appearances that were allowed to be done via video during COVID, once those emergency orders expired, we were not able to do that. So So we've been working really hard with our Supreme Court to actually see, and we provided them with a lot of data in terms of trying to be able to continue some of these things that by statute, technically, there has to be lots of agreement with before you can do that. And pretrial system performance metrics, you always want to make sure that you're measuring what you're doing so you know it works. And then when you have issues, you can go back to issues, you can go back to your data and say, look, this is what improved. We would have never been able to go back and say like, oh, we improved our appearance at preliminary hearings by like 7% if we didn't keep the data. And now I would like to turn it over for pretrial release and detention decisions to Elizabeth Simone.
Thank you, Janice. Good morning, good afternoon, depending on where you are. So in this slide, we're really going to talk about one of the pieces that Kenny referred to in the introduction. These standards are aspirational, but they're not unrealistic. And that's going to set the framework for my comments here. In standard 3.1, it talks about jurisdictions developing guidelines that authorize law enforcement or criminal justice agencies to release individuals before the initial appearance. An earlier standard in this same edition, which is standard 2.1, describes release options that are available to law enforcement officials. The standard here, which is 3.1, encourages expanding the release options to other criminal justice agencies, such as pretrial services or a jail authority. This type of delegated release authority can be granted by the court and must be permitted by statute. In order to do this well, and this is the piece where it's not unrealistic, even if it seems aspirational, there should be policies and procedures for delegated release, and they should be reduced to writing so that criminal system actors and partners are all aware of what that is. The second bullet is our stated preference for release on OR with conditions ordered only when risk levels or factors permit. So these would be individualized factors related to future court appearance or public safety, and they should only be added if they need to be. And we would know that from our pretrial outcome assessment and other information that we gain during the investigation. The next bullet, clearly defined criteria, population eligible for pretrial detention. This is a big deal. The bail, no bail dichotomy requires a variety of bail options available to the court and to system partners. When we use no bail as an option, that can only happen if the likelihood of pretrial failure presents as unmanageable, meaning no condition or combination of conditions that would mitigate that risk, and only if statute permits. Detention is the most restrictive thing that we can do in the system. So bail laws and court rules should clearly identify the limited circumstances in which this option can be exercised. And they should include, and I would say must include, procedural requirements that safeguard due process and protect against unwarranted pretrial detention. So again, sounds aspirational, but if you have a process in place and you clearly outline it and work through it with your stakeholders, it gets you one step closer to doing this in a way that the standards would uphold. The fourth point, finally, subsequent review of release and detention decisions. In standard 3.5, judicial officers may at any time modify bail status to address conduct or material changes of circumstances. This standard talks about only the court having the authority to modify. The court may permit, however, a pretrial services agency discretion to modify release conditions based on individual behaviors that the pretrial agency observes or witnesses. So another interesting aspect, and Janice referred to this going through the essential elements, that I think this standard contemplates is the sequential bail review process. A pretrial service agency can review the status of detained individuals, reassess eligibility, and there's also that report back function that she talked about to assure that parties know when and why an individual remains detained. Can you advance to the next slide, please? Thank you. In this slide, we're going to talk about pretrial service agencies, and the purpose, functions, and management of them is how we begin. This is embodied in Part 4 of the standards. If you're new to the standards, Part 4 can give you a guidebook and guidelines about how to do pretrial services in an agency, and even some pointers on how to create that independent function. First, the purpose of a pretrial agency is to assist the judicial officers in making prompt, fair, informed bail decisions that maximize release, maximize appearance, and maximize public safety. This gets us closer to an equitable system. Pretrial agencies can also provide practical, individualized monitoring, supervision, and support options for individuals that require the oversight. They should track and report the outcomes and performance measures. In Standard 4.2, the pretrial service agency is described as needing a governing and organizational structure that's designed to meet the mission and the objectives. So this is talking about where pretrial sits or what the locus of control is for pretrial. The goal is to enable neutral performance of its functions. So it should be structured to ensure independence in an adversarial process. So you think about not being aligned with defense, not being aligned with prosecution, not being aligned with law enforcement, but having that independent ability to be neutral in a process. And Standard 4.2b lays out a lot of detailed considerations to achieve this. Core functions of pretrial include background investigations, which may or may not include a defendant interview, depending on what type of process and tool you use. The use of validated pretrial outcome assessments, pretrial recommendations to the court, monitoring and supervision, consideration of workload and caseload rates. And as Janet said, that's a newer standard for us. The standards don't give us specific ratios. Did you want to speak? I'm sorry. I heard background. Due to differences nationally in how pretrial agencies perform mission critical tasks, but this standard does offer guidance for the field in looking at how work units can be measured to assess a workload and how the average time available per staff can be used to quantify what that workload looks like. And then finally, but equally important, is confidentiality. In 4.8, we look at what specific written policies can outline confidentiality of agency-related information. And this really is the when, with whom, and how information can be shared. Thank you. I'll turn it back to you.
Thanks, Elizabeth. So Standard 1.5 is your financial conditions of bail should be prohibited. That standard further goes on to say that pretrial service agencies should not recommend financial conditions of bail. So that's one of the things that when you have a good pretrial system, that's something that you talk about, because there's basically only one state that has really gotten rid of cash bail at all. Like they can't use it. And so every other state usually has some type of financial conditions of bail. Pennsylvania, money's still on the books. The judges can still set money. But as a pretrial program, we have not, at least here, we have not recommended money since 2007. So we would never recommend a financial condition of bail. When we first sort of changed that, the judges were used to, because we used to say like, okay, aggravated assault, 5,000 sounds good, right? And it was kind of like a standard. And so when we stopped that, they're like, come on, just like, if it was an aggravated assault, just come on, tell me what you think we would do. And we were like, no, we are not we're not recommending any money. So even though money is still used here, it's not something that we would ever recommend. And it took 3 years for the judges to get used to us not giving them a money amount, but now they wouldn't even think to ask. I will tell you that we in 20 like maybe September, October of 2024, we decided we wanted to look at as many bails as we could and see what conditions were set. And so we looked at like 2,300 bails that were set from September 2022 to August of 2024. And we found that individuals released on a monetary bond had worse rates of court appearance, new criminal activity, and overall pretrial success than any other bail condition that was set. So this was sort of our first time looking into some stuff like that. So stay tuned. I'm hoping to have something a little bit more concrete, and we're kind of breaking it down into bail conditions. So so what county are you in? I'm in Allegheny County, which is Pittsburgh. We have 46 judges that set initial bail, and listen, it was a really big fight. But what we did do and how we got this to sort of become standard practice is that our administrative judge, we convinced her that this was the best, like this was right, and this was the way to do things, and we should not be recommending money to a judge that has that final decision. And she bought into it, and she was in charge of them, and that was the end of that. So you have to find that champion, and the champion can't be you, right? Because people don't listen. You need like someone at the top to get to that. So, you know, it's difficult, but it is work that can be done. Kenny, Elizabeth, you're up next. Sorry, thank you.
Thank you, Janice, and that is really interesting. I look forward to seeing what else comes of those data polls and examinations. So standard 2.7, this is possibly one of my favorites, simply because I work at a private nonprofit agency in Maine. This standard clearly states all jurisdictions should establish a dedicated pretrial service agency. Music to my ears when I am fighting the good fight in my state. So the case for dedicated pretrial services is really grounded in a few things. Organizational theory, which I cannot articulately explain to you today, but it is the complexities between organizations and the systems in which they live and operate. And then opinions and recommendations of leading criminal justice organizations. One that supports this would be the American Bar Association, for instance. And then finally, the law. That is how we come to this declaration that all jurisdictions should establish a dedicated pretrial service agency. We would encourage looking at commentary on 2.7 if you really want guidance and support for establishing, or equally importantly, maintaining a dedicated and independent pretrial agency in your jurisdiction. You may have one, but to keep that independence and that neutrality, there's a lot of information that these standards can share. The quick bottom line for you today, the standard recommends a few things: a separate, independent entity. Jurisdictions can incorporate pretrial agencies within a larger parent organization, such as a court or a county or a department. But if that pretrial agency that's created retains clearly defined pretrial service related functions as its purpose, staff assigned only to pretrial related work, and management that can make independent decisions on budget, staffing, and policy. Otherwise, you have to go with the flow of whatever your organization is. So take a look at 2.7. Hopefully that helps you. And I'll turn it over to Kenny. Thank you.
Thank you. So standard 3.3, and this is, we believe, one of the most important standards that NAPSA promulgates, because it really gets to the basics and what is a good, well-informed release decision. As you can see from this standard, all persons should have the presumption of own recognizance release, with the requirement that they report to court as required and not commit any offenses while on supervision. Certainly, if you are the government with that limited duty to protect public safety and to ensure court appearance, you can argue that there are other things needed, other conditions of supervision that might be needed to get those two things accomplished. But you have to show reason why you believe those conditions are necessary. There has to be a specific risk factor that you're trying to address. You simply cannot say, as Janice said earlier, this person is charged with this kind of crime and everyone charged with this kind of crime gets this kind of condition, or that we have a recommendation matrix in place or release matrix in place and everybody who hits in this box gets these sets of conditions. Bail conditions have to be individualized to the person. And if you don't do that, then you're not meeting the goal of this particular standard. They also have to be the least restrictive needed to address the identified risk. So those are the requirements, we believe, of a good bail decision. You start with the least restrictive option. You move up only if you can find a release a risk factor or a risk level that requires something above own recognizance release. Standard 4.B talks about the functions that pretrial agencies should adopt in order to support their courts and support their justice systems. We, as NAPSA, firmly support the idea of collecting and verifying background information and criminal history information, conducting those kinds of pre-arraignment interviews. We support assessing the likelihood of future court appearance while on pretrial release, using a pretrial outcome assessment tool, and that tool using factors shown by research to predict the likelihood of pretrial failure. Using background interview information, criminal history information, the outcome assessment results, and others to formulate an appropriate recommendation to the court. What we believe as an agency is necessary to ensure that person's future court appearance and public safety. We believe that agencies should have the capacity to monitor and supervise persons who are released in accordance with those court-imposed conditions. Options should include behavioral health services and treatment. And this is when the fun part comes and we do question and answer. While NAPSA believes that these options should be part of supervision, we don't necessarily believe that they should be conditions of release. These kinds of behavioral health services and treatment should only be imposed as conditions when that need that you see becomes a risk level itself. We'll certainly have some questions about that, I'm sure. You notify the court, prosecution, and defense about a person's compliance with release conditions. And when appropriate, you recommend appropriate changes to that person's release status. And very importantly, you continue to review the status of detained defendants to determine their eligibility for pretrial release. Most people are detained not because they are a risk to miss a court date or a threat to public safety. They simply don't have the money to be released. In those instances, it's especially critical that pretrial agencies continue to review the status of those individuals, and when you can, make recommendations to the court for release. So before we do questions, I will let you know that there is a survey that you can follow at the end of this. We'll broadcast this again after Q&A, but this is a survey that you can take to let us know what you think of the standards themselves and this presentation. So I will stop sharing for a moment so everyone can see all questions and answers, and we'll open it up to any questions that we might have. Wendy, are we going to go into the chats and do that, or how do we want questions to?
In the Q&A, please.
In
And
the
it looks
Q&A.
like there's been 4 answered so far, and we have another one up there from Jody Giroux.
Okay.
Yeah, so just real quick, I just wanted to, we did answer some of these, I think, on the thoughts on pretrial service agencies housed in probation and peace officers doing the work, right? So Elizabeth put in the Q&A the standard 2.7 for some guidelines regarding insulating pretrial services from law enforcement and that process. But you know, I think that one of the big things is and she put that in there, like their own mission statement. You don't want probation officers like, okay, I'm going to go see these convicted people in the morning and I'm going to do the non-convicted people in the afternoon. Like there has to be a clear delineation of work. I understand in Pennsylvania, we have lots of pretrial programs that are popping up in probation, right? And so I spend a lot of time like, that's fine. I understand the resource issue, the money issue of getting people, but you also have to understand that like there has to be that clear delineation, and it can be done. You just have to be very, very deliberate about how you're structuring that and who's reporting to who, and they have to have their own mission, right? It seems odd you have like this overarching mission at your probation department, but then you have a mission for pretrial units, right? And it's separate from that, so.
And if I may, as a potential NAPSA resource, we have different regions in the country, and you probably know which NAPSA region you are in. But I think about in the region where I work, it's been helpful for me to be part of a community of practice by going to regional meetings. And I've encouraged people in a neighboring state that does not have well-established pretrial services and really struggles with, I can do it under a law enforcement hat. They want to fund this out of a sheriff's office, but how do I figure this out? Come to a community of practice, come to a meeting in your region, get support. You'll also have access to the latest in terms of court decisions, opinions, things that are happening elsewhere, bail changes, and you'll make some contacts who can support you and talk through those difficult questions.
I'll just put the shameless plug because I'm the Northeast Region Director and I do host quarterly meetings, which Elizabeth attends. So to figure out your region, you would just go onto the NAPSA website, and then whatever state you're in, it'll tell you what region you're in. Yeah, so I host quarterly meetings, and like if you send me your email, I will, and you're in my region, even people that aren't in my region, I probably would put you on. But then we sort of talk about, they're an hour, it's over lunch, but you know, and then when you become on that list of people, I usually, if there's new research that comes out, if there's things that are interesting that we, you know, come across, or as the board sends a lot of stuff back and forth to each other on things like that. I'll forward that out to my region also, just in case you want it. So yeah, you can figure that out.
So I'm looking at the Q&As. There was number 1, a question about the use of GPS not being evidence-based and the like. That really applies almost to all the conditions of supervision used by pretrial agencies. There really isn't a condition that has evidence behind it. We've done it because we've always done it. We took a lot of the practices that we have from our brothers and sisters in probation and parole, and making you report weekly and drug testing you and slapping a bracelet on you with things that they did. So obviously it made sense that we do it. I think and I say this as a complete non-expert, as a researcher, but I think one of the reasons why we don't see these conditions being effective is that we use them too often. If everybody has a condition, you shouldn't expect that condition to be effective. So if we were a bit more selective about the people we place on these conditions, I think we might start seeing some research that shows some benefits for those particular limited populations. Another question, could you speak again to the workload caseload standards? Where to, okay, where to locate info for that best practice? Yeah, the NAPSA standard that talks about workload and caseload analysis does include some citations for work that have been done recently. This is something that is very, very new to the pretrial field in terms of studies looking at individual agencies and what they require when it comes to staff and resources. There have been workload analyses on pretrial agencies from Maricopa County, which is Phoenix, Arizona, Houston, Texas. I used to know these by heart. The state of Virginia just did one recently statewide. All of those can be found as citations in the NAPSA standard. Uh, Todd, is drug/alcohol testing being frowned upon because research, oops, I just lost you. Because research is not showing a direct link to FTAs and new arrest. I heard this stated recently and disagreed to the extent that not testing could be a risk to communities' safety. Your thoughts? I'll let somebody else talk since I've been talking way too much here. You're on mute, Janice.
Thank you. You would think after all this time, I would remember that. So I think that when you're talking about drug and alcohol testing, there should be a reason for that testing. And then if you're gonna test, like we have sometimes someone comes into the office for supervision and we've had people where you could tell something was going on. And then we would offer them services, right? We'd give them drug and alcohol services, mental health, like whatever we need. What you want to be really careful of is, I mean, we've had judges that order people to drug testing. They have to come in every day for drug testing with no follow-up, right? Drug testing alone doesn't do anything for the behavior. It just makes you know that someone's using drugs. You have to be able to offer them something. I do caution, because we sometimes end up with this issue here, is when you are drug testing and you're offering people, that you're over conditioning people, right? We have lots of times where, a judge will say like, oh, you have to go to inpatient treatment, and they're stuck and they can't move, right? Sometimes out of jail. And when they're assessed, they're not even being assessed at a level to attend inpatient treatment. So there should be some type of assessment involved before you order any of this, any type of drug testing, alcohol testing, treatment, right? Everyone thinks like, we'll send them the treatment, that'll work. But if they don't need the treatment, and then all you're doing is really just, making people do more things that they may not need, and then you're increasing their failure level when all you really need them to do is show up for court and not get a new case.
And just briefly, there are some non-proprietary screening tools that may be useful if a pretrial practitioner or a counterpart in the system wishes to do quick screening confidentially for the presence of substance use disorder, mental health, or trauma. A great one is called ACOK. It takes a couple of minutes. The other thing that I would say is we were fortunate in Maine. About 3 years ago, our legislature abolished random search and testing for pre-conviction cases, and articulable suspicion is now the standard. We track our outcomes. We did not see any increase once we stopped doing drug testing randomly that impacted public safety negatively. So that's some helpful information, hopefully.
This from Christine. I'm sorry, go ahead.
Good. No, I was just gonna, so we've been discussing the idea of not making a release recommendation, but rather providing the information to the stakeholders. Hearing that this perhaps is not a direction to take, and then we should continue to make a recommendation. I appreciate your thoughts on this. So I'm not sure, like, what are you talking about for stakeholders? Let me just, am I like misreading this, or are you guys?
I was drawing a distinction between specifying a recommendation about what the release should be, meaning in some jurisdictions, unfortunately, financial or no release or
Right.
release
Okay.
with conditions,
Yeah.
but instead providing a report that has information so that the judicial officer can factor that in. But I may be misinterpreting the question.
Yeah, so if you're just gonna if you're just going to give a report, we don't always make a recommendation, right? Sometimes we give the report and there's information in there on success rates. So all of our stuff has, people that score this, 97% of the time they appear for court, 91% of the time they are not getting rearrested. And we also 2 years ago added violent rearrest into that. And so sometimes just giving them the information to make their decision, is the way to go. I mean, in my opinion, the judges were elected to make those decisions. And so we give them the best information that we have to help them make the best decision they can.
So I can grab the next one if you like. Behavioral health services or substance use disorder services not being added as conditions of bond. Pretrial services agencies referring based on need of defendant. That's a practice that I think is correct. A condition of release has to be tied to an outcome that we're predicting that poses some type of risk. And because behavioral health issues are not always seen as criminally related, perhaps not driving criminal behavior, but are more of a public health issue about wellness, basically. I can offer what we've done in our jurisdiction. We do not condition that way. If a court orders it, then we will uphold that condition. But what we do is we use motivational interviewing techniques to try to engage with the individual who's there for services. Like Janice was talking about earlier, what do you need? How can we help you? And apply the resource instead of having it be a court-ordered condition, certainly not one that we're going to recommend as a pretrial agency.
This really goes to the purpose of bail and the differences between handling a presumed innocent individual and someone who's been sentenced. At the pretrial stage, the government's interest here is extremely limited. Ensuring court appearance and public safety. That's it. Those are the only two things that the government can do. If my need, be it a behavioral health need or a substance abuse need or whatever, doesn't rise to the level of risk, doesn't rise to the level of my missing a court date or being rearrested again, it cannot be considered as a condition because it isn't needed to get me into court. It isn't needed to keep the public safe. If that need, however, becomes a risk, then certainly you can consider these as legitimate conditions of supervision. The problem is most jurisdictions don't take that extra step. It's, I'm going to put you in treatment because you're using drugs, whether that treatment is needed to advance the purposes of bail or not. If you are doing as Elizabeth described, using an outcome assessment and also a needs assessment, and if those two instruments are pointing towards this need becoming a risk, then yes, you can consider these as conditions of supervision. If you're not, then you can't. You shouldn't. They can be services, they can be supports, but they should not be court-ordered conditions of supervision. Again, you're dealing with people who have far more rights than someone who's been convicted. The purposes of what you're doing is much more limited, and you have to be considerate about risk and not so much need.
So I'm going to take the question. Many agencies using the PSA no longer do pretrial interviews. Can you speak on pretrial interviews and your view on approaches that don't include an interview? So we also, in certain circumstances, use the PSA, which does not require an interview. Our locally validated tool does. I would say that an interview, if you're going to be supervising someone, or even if your court sends out court reminders, getting certain information from someone is critical in that. So if you're going to send text reminders for court dates, right, you want to make sure that you're getting that information. If you're going to have someone's, if you're going to be supervising them, you want to know where they live. If you're doing those type of visits, if you have someone coming in. So there are certain pieces of information that you would want to get. You can do this without an interview. Of course, the PSA does not require an interview. And I believe there's one or two other current assessments that don't require an interview. But if you can have access to an individual to get some of that information, it can be very helpful in making sure that they appear for court and comply with the conditions of supervision. Anybody else, anything?
I'm good with that. I think we skipped a couple of.
Yeah, I'm trying to look and see what we.
Yeah, this is from any recommendation on how to make that transition away from financial conditions and to encourage the court to detain those who obviously pose a community safety threat. Our state requires that financial bail be considered even in the most heinous cases. Funny thing about financial bail in most states, you're not supposed to use it when it comes to community safety. Financial bail in most jurisdictions is only supposed to be used to help ensure a person's court appearance, not to ensure public safety. Although we know that most times when bail is set, it is set because the person is presumed to be risky to the public. I think for pretrial agencies, and I'll go to how we did it in Washington, D.C., and how I know other jurisdictions are doing it. In your recommendation, the wording is quite simply, we have no condition or combination of conditions that will assure this person's appearance in court or the safety of the community. You're not recommending detention. You're simply being honest with the court that for this particular individual, there's nothing your agency is able to do to alleviate or mitigate any of the risks that you've identified.
Is it advisable to have the same staff who do PSAs to also serve as case managers? Where can I find that research? Is it a part of the standard that Kenny was speaking of? I apologize if I missed it earlier. I'm not sure what standard.
Yeah, we didn't have a standard about what duties staff should do. It was just how many staff you need to perform those functions. I don't see a problem with having people serve that dual role, that you can be both a supervising case manager and the person who prepares the information to go to court. In fact, in most jurisdictions, I think that's how it's done. You just don't have the manpower to have those kinds of separate units.
Agree.
If I may interject, I accidentally put a statement that had been in the Q&A into the answered question. I was just trying to comment, and unfortunately it closed it. So I'm trying to get back to it. Donald Jones said, I truly believe that GPS monitoring is only effective with clients who would be compliant even without it. I see no value in its use in Illinois. The only value is if the monitored individual commits another crime and law enforcement can prove that they were at that location, assuming it wasn't removed by the monitored individual. I just didn't mean to move that without you all being able to see it and potentially comment.
I think there's another question. When there's a nexus between criminal conduct and substance use disorder, our court will order UAs. When we case manage the client towards evaluations, treatment, etc., and they continually show non-compliance and continued use, what should a pretrial program do? Sometimes our courts revoke release. I, I, I need to think about what I'm about to say here. I think it's foolish to say that I'm putting you in treatment because I know that you have a substance use disorder. And the minute you use drugs, I'm going to punish you. I'm going to lock you up. Treatment doesn't work like a magic bullet for most people. People who are placed into treatment are going to continue to use. That's why you put them in treatment in the first place. You, as a pretrial agency in your courts, have got to realize you're going to see more failure in treatment than you're going to see success. This is a long-term thing. And if you're going to adopt a zero tolerance policy, or if you're going to freak out the first or second time, then maybe you shouldn't be doing treatment. I would talk to the treatment providers in your jurisdiction, have them sit down with your courts and really explain what this process is. If you really have identified the appropriate population of people who need treatment, then you're going to have to realize you're going to see failure. You're going to have to accept that, and you're going to have to be in it for the long term.
I agree with that, and I had put in the chat, but then I think I lost it somewhere on one of the other questions that was related to behavioral health. It's really important to understand what someone asked, how they would determine what provider was appropriate, if it was a good referral, how are pretrial staff trained, or are they certified to make those determinations? And I think, as Kenny said, it's important to talk with organizations. You can have your administrative leadership go to an organizational leadership and say, what do you provide? What's your level of licensure? What's your experience? And I think, very importantly, what is your experience in working with people who are justice impacted or involved in our system? Because a lot of people can overpredict risk. A lot of people can overpredict concerns about working with someone that's in a criminal legal population. You need to make sure that the provider you're referring to actually can do the work, does it comfortably, and understands that a substance use disorder, once diagnosed, is a chronically relapsing situation until people get into remission and recovery. The other thing is having some understanding, if you need it, around what your expectations are and how that person will be served, how communication will flow from an organization, either to you or the court. I would just put a plug in here for working with people with lived experience who are certified as peer professionals, peer navigators, and peer support.
Though one more question is from Tara. During the bond phase, is it appropriate to order treatment as a condition? In Medina, Ohio, we have people complete an assessment, but not necessarily require the treatment during bond. I would say that I think that it's, if you're doing an assessment, and I think Kenny sort of answered it before. So if you're doing, a pretrial outcome assessment and also a needs assessment, right? If that looks like those needs are going to become a risk, then yeah, maybe you would want that to be a condition. But other than that, you would just want to offer them the services, right? So, we have lots of, in our supervision area, there's all kind of stuff we put out and people could take it on their own. And a lot of people do take it and they, of course, use it. It's just not a condition. But, and we don't know at that point, like if they didn't take it, would they have still come to court? I don't know that, but I don't think I need to know that either, right? I just need to offer it. And if they want to take, advantage of that service, then they can. It's just like we had a judge that all the time ordered, get your GED, right? It was part of a bond condition. And like, what risk factor are you trying to address? Like, are you worried that they can't read their subpoena so they don't know? And they're like, absolutely not. I'm not worried about that. Well, what are you worried about? Well, it'll make them a better person. Like, and I said, I'm not trying to be insensitive, but really at the pretrial stage, do I want to make them a better person? No, that's a post-conviction, right? Long-term recidivism, like productive member of society. Right now, I want you to show up for court and don't get rearrested, right? If you're a crappy person, as long as you come to court and don't get rearrested, that's, no, I'm not fine with it, but that's really what my goal is.
From Christina, if a client gets rearrested while on supervision, but charges on the new arrest are not filed, is that counted as a rearrest? Under the NAPSA standards and under the National Institute of Corrections measuring what matters, it would not be. A rearrest under those two documents has to be a charge, a filed charge. Now, there's a difference between saying a charge didn't get filed and a charge eventually got dropped. If a case is dismissed, but it was filed, that counts as a rearrest. But yeah, if it wasn't filed by your prosecutor, we don't consider it to be a rearrest. And I guess sorry if I missed this, but can you share more about the standards that focus on performance measurements? What data elements should programs collect, public safety success rates, or, well, and then it stops. Yeah, the outcomes that the standards recommend are your appearance rate, your public safety rate, release rate, and what is the last one, Kenny? Concurrence rate?
Yeah, concurrence.
Okay, I only wrote the darn thing, and I shouldn't have to remember it. Yeah, so most of the data is going to come from not the pretrial agency, unfortunately, but from other stakeholders, principally the courts and probably your Department of Corrections. Your court is going to have to, or if your jail, if it keeps that data, someone's going to have to let you know if someone got released. You're going to have to be able to count bench warrants to see whether or not uh, about the appearance rate. You're going to have a definition of rearrest, and you're going to have to be able to say that here's a filed charge that happened while another case is pending. All that information really is going to have to come from an external source. So in a lot of ways, and this is something that we've always stressed, these are not a pretrial services agency's metrics. These are a systems metrics, and you're going to have your system partners really help you in putting those together. Heather, is there any materials regarding the reporting frequency based on the risk tool for pretrial defendants that I can reference? I believe we over-supervise pretrial defendants as they report more often than those placed on probation. I think that, if I'm not mistaken, Arnold Ventures does have suggested or examples of recommendation matrices on the PSA website. Advancing Pretrial Policy and Research, APPR, certainly has this information as well. So I think those are two good sources for you. Heather, you really point out one of the big problems and one of the things that the standards really try to emphasize. People are being over-supervised. Conditions are being overused. I can't think of a good reason to have a person report to me weekly. I really can't. I've never was able to, especially someone who's working. And employment is one of those factors that we know helps reduce recidivism and rearrest. Yet I'm going to screw with you because I'm going to make you come downtown and meet with me for 20 minutes. It'll probably take you an hour to get back and forth. I'm going to make you leave your job or ask your employer to take that much time off. And I'm just going to do it because that's the way I've always done things. And by the way, my office hours are 9 to 5. I don't work weekends. So you can't come in on a Saturday or a Sunday to check in. there has to be a good reason to make a person do all that. And I've never been able to think of that. Something that can't be solved with a telephone contact or these days a virtual contact. Um, Making someone report more than weekly is just, you're just screwing with them at that point. You're not really supervising them. But yeah, I would look on those websites and if they do suggest some frequencies of contact.
Yeah, we do. So we have that initial, you come in for your initial, we explain to you, we, give you our support wall, right, which has all of our stuff on it. And then, if you come in, 3 weeks after that, and then from there, it's court date only, right? If there's been no issues, we found, through, data that, almost like 93%, 92%, something right around there, of all of the failure happens in the first like 40 days on our supervision. And so after that first and then that second, when you're in the city for your court hearing, you can stop by. So that's just the way we do it.
From Casey, is NAPSA planning to or beginning to look into possible standards regarding some of the new immigration laws and policies that are being put into place in various states? I don't think so. I'm no longer on the board, so I can't answer that as a clear yes or no, but I don't think we're looking into those laws. That might be something that goes into a future version of these standards, but yeah, I don't know the answer to that.
There's a follow-up from Norris Gregoire. Situations where continued use elevates the risk to reoffend. We look at it with certain types of people, but they have become higher risk. At the very least, I think a return to court for a status hearing might be warranted, question mark.
Well, I guess my question, and reoffend's not the right word because that assumes that I committed a crime and just got convicted of it. Has the person been rearrested again? I guess that would be my obvious question. Is this something that you've seen? Is this person back in the court system and they're back in the court system because of their drug use? If that's what you're looking at, then yes, then again, treatment becomes a legitimate condition to consider. If there's no change in the person's risk level or the like, and you're just assuming that because I'm using and using, you're going to see me again, that's not enough. I would still say that you need something more than that.
So the next, to count an FTA, are you counting the FTA only when a bench warrant is issued? What if the defendant shows up a week later and they never issued the bench warrant? We only count when the bench warrant is issued, right? Because a lot of our courtrooms do things different. Some, if you're 5 minutes late, the warrant's already issued. Some, they issue them. If you don't show up by the end of the day, they issue them. Some of them, like the judge wants their staff to try to get in touch with the attorney to get, so they wait a couple days. So we only count them if the bench warrant is issued.
From Christine, would be interested in knowing what tools for domestic violence lethality assessment that have been validated for pretrial are being used. I don't.
So I think a lot of jurisdictions, and I know Elizabeth can talk a lot about this because, but the ODERA is usually one that is used in jurisdictions in conjunction, not in place of a pretrial outcome assessment, but in complement to it.
Yes, the Ontario Domestic Abuse Risk Assessment, it was created in Canada, but it has been validated in many US jurisdictions. It's been validated and revalidated in Maine. We've used it for many years. It actually is written into our state statute that first responders will utilize the tool. Our staff, under direction of one of our domestic violence experts, has continued to perform the tool because it helps us understand what some of the risks are and how we might be able to address them. It's predictive about future reoffense with the same named victim. So it's tricky from a pretrial point of view in that we don't have a conviction, but it's a helpful tool. And it is highly predictive. There are other tools. Jackie Campbell's dangerousness assessment is used in a lot of jurisdictions. It's important to note what Janice said, and I'll underscore it. We don't replace pretrial outcome assessment with a specific tool. We call them stacking tools. They complement. And for us, we really look at what is the risk for appearance, what or non-appearance, what is the risk regarding public safety, and then what is the specific risk we're trying to target with this specific tool. And I would say the same thing around the needs that we talked about with substance use disorder as a separate stacking tool.
Okay, long shot, I know, but could NAPSA come up with some type of program system everyone could use to collect the measuring of matters data so we're all collecting it the same way and accurately? That would be lovely and amazing, but I think that jurisdictions are so varied in the way that they log stuff and view things that I think Kenny would know better, but to me, I would love that, but.
Oh, yeah. I think we could all retire tomorrow if we could do that.
Yeah, exactly.
Yeah, you're right. The systems are so different that I don't think a one size fits all solution is out there. I do know that a lot of software vendors who deal in pretrial systems are beginning to put metrics into those systems to help agencies count them, and even that is quite difficult. But as much as I would wish we could do that, I just don't see that happening anytime soon.
I do want to add just a tiny bit to that, because that is something that I've heard a few times. And honestly, based upon my individual background, that's something that I am very interested in, as I think all of our panelists are, or interested in exploring. Thank you for that comment. That actually perks up my ears a little bit. And I also did want to say, not necessarily closing out here, but just to say a couple of things that I had mentioned at the beginning, but one I did not. And that is, we are at NAPSA hopefully going to be putting out an interest survey. And so just a survey about various items for both members and non-members, people that are just interested in the pretrial field, including all practitioners. We'll be hopefully putting that survey out in the coming weeks. And there are questions related to data collection and analysis on that. And so be on the lookout. Typically, when we put information out, including the webinars that will be upcoming that I hope to be releasing in the next week, we put those out first to members, then to those folks that have attended our most recent conference, which was in last year in New Orleans. And then I also put that on our social media channels, which are Facebook, X, and LinkedIn. And then also I put them on the CSRC community as well as the APPR community. So if you're hooked into any of those, please look for our announcements there. And if you're not, please consider either joining or coming to a conference, or joining us on social media, or joining APPR or CSRC's communities. And so I do see another question, so I'll be quiet now for a moment.
So just real quick, I think, and Wendy was sort of alluding to our next kind of round of lunch and learns, whatever you want to call them. I don't know. It's lunch for me. So, but we are doing one on sequential bail review is going to be, I believe, April or May. Not real sure yet, but it's yeah. April. Thank you.
And in May, just to kind of give that preview, and I'll just stay on video. In May, we're going to be doing one on NAPSA accreditation. Those are the one that Janice just mentioned on jail review. That is pretty concrete, and the one in May on NAPSA accreditation is also starting to solidify. So I'm pretty certain enough to say it out loud that those are both coming for you.
So Liz, you're answering one question. There's another one. Where can we find the information regarding caseload ratio. So mentioned the new standard on workload and caseload ratio includes a citation that quotes a couple of studies that have been, at least 4 or 5 studies that have been done on pretrial agencies specifically. As I said before, this is really new territory. I think most of those studies are no more than 10 years old, but you can check the standard and see the citation there.
And I was trying to type, but somehow indicated I would answer live. Hello, Doug Coppin. Great question. Moving away from the traditional standard, failure to appear, and more towards a willful standard. That's something that we support. I know we did a presentation last year about that, and there's a publication in terms of a standard definition that the bench could use to help make this determination. I think about rule outs, almost like a medical community would. Can we rule out that the person had transportation issues, childcare issues, health issues, medical issues, poverty issues? I don't think that's helpful. Kenny, what are you? I see you about to say something.
Did they renew their passport and go to Canada, right? Like that, so that
Okay, sure.
a
And
question.
one of the things that we talked about when we made the presentation last year or the year before was pretrial service agents, if they serve a case management role in supervision, they can independently verify some of the barriers for the court, and that can be really helpful. They can specify, my person could not get there. They do not have a vehicle. There is no public transportation available in this community, things like that.
From an attendee, is there a standard of an ideal caseload size? Unfortunately not, because different agencies do different things. So if I'm an agency that has, let's say, a couple of conditions that I'm offering to the court, my ideal caseload sizes will be different than an agency that provides for, GPS and reporting and other higher end conditions. So the more of those kinds of conditions you have, the fewer people you should be supervising, as a case manager. But no, there is no ideal. The standard talks about how to go about getting that, creating the work units and what should go into it. But no, we don't make a recommendation about ideal caseload sizes.
I would just put another plug in for your regional networks that can help you. If you find an agency that looks similar to yours in terms of population, it's rural or it's urban, or it provides the whole complement of services that Kenny was talking about, that could be a good guide to explore some of those caseload ratios with a peer.
Great. So it looks like we are out of questions at this point. We are nearing the end of our time. To Elizabeth's most recent point, I did put in a link to our website that talks about the regions, identifies what states are in which region, and then also the regional directors, of which Janice is one. And so anyway, you can find contact information on there, identify your region, and then reach out to your regional director, and they're hosting regular meetings of their region, talking about what's happening there, making connections between people. In some ways, I know that there was one put in the chat from the Illinois Probation and Court Services Association is hosting a free webinar. The link is up above. Michael Vendetti put that on there. So you'd find more access to resources like that as well within your region of what's happening. I know that in Texas, the TAPS conference is coming up in May. That's always a really good one, and quite a few folks from that region, not just Texas, attend. So that's one way to get involved. That's also a way to find out about resources to network with peers. So really kind of take advantage of your regional directors. And if there are no other questions, I wanted to make sure from our panelists if there's any other parting comments.
You want me to put the QR code back up again for those who might want it?
That would be great. Thank you.
Okay. Well, let's see if I can get to that. And let's just go back. Oops. How about going forward? Okay, there it is.
Thank you, Kenny. So yeah, if you all could take a moment to fill out that survey, we would greatly appreciate it. As you're aware, I hope we have been hosting these free webinars since October of last year. They've been very popular. We're super excited to be doing it. And the survey gives us an opportunity to improve, to bring you more content that is relevant to your work, and to just better serve the field. So please take a moment to do that. We greatly appreciate it. As we've mentioned a couple times, we have more sessions coming up in April and May that'll be announced very soon. I'm hoping to put out a survey also within the coming weeks that will ask about just global questions related to NAPSA and how we can better serve the field. We will also be opening our registration for the fall conference, which will take place in September in Atlanta, Georgia, hoping to open registration for that in April. We had an overwhelming number of submissions for possible workshops at that. I think we were over 100 submissions. And so we are also planning, I don't have the good quote here yet to be able to tell you precisely what it is, but I am hoping that we're going to be able to offer a record number of courses in our September conference in Atlanta. So a lot of exciting things happening at NAPSA right now. I'm very proud and honored to be a part of it. So grateful that you were all here with me today, or here with us today. I apologize. Any last comments, again, from the presenters? I don't want to. Nope.
No. Well, I'll just say that as the Association of Pretrial Practitioners, we're committed to making sure that the standards always meet best and promising practices and match up with case law and match up with what states are doing when it comes to reforming their bail laws. Something we've committed ourselves to, and the field will be seeing more regular updates to the standards going forward. Also stop sharing.
Outstanding. Okay, well, as we said, this is being recorded. It'll go on our YouTube channel within the next couple of business days, so you can look for it there. And otherwise, thank you all for being with us today. It's been a pleasure, and have a wonderful rest of your week.
Thank you, guys.
Thanks.